and retention. When this matter came up some time back, the applicant wanted to proceed, but the respondents through their counsel made an application to have the deponent of the applicant's affidavit cross-examined. This is just to bring you speed. Cross-examine. The applicant also wanted to have the matter heard in chambers, something which defense counsel vehemently objected. The trial magistrate, chief magistrate then, ruled that the matter would be heard in chambers for the application. But defense were not contented. They informed the court were seeking a revision in the High Court. As this Honorable Court, one, halt the proceedings in that application, forward the file to High Court, and three, avail the record of proceedings. We had objected to that, the issue of halting the proceedings, forwarding the application to High Court, and also to avail defense with the record of proceedings, because it is not one, or they are not part of the functions of the trial magistrate handling such an application to do in case the respondent or one of the parties opted for revision. Out of respect and courtesy, the trial magistrate allowed and availed to the record of proceedings, put it on the ECMIS, and also...
I'm sorry to interrupt you, Worship. We are at a loss as to what is going on. Is he proceeding with the matter? Is he not proceeding? What are we here for? Because what we are listening to does not add up to us.
Your Worship, just bring you to speed because you're not part of this application before. And I think I'm the order.
But there is a record, there is a file, there is a matter before the court.
Counsel, let him just conclude.
So when this court allowed counsel for defense in the lesser judgment intimated that the court that they had filed an application for revision in High Court. But it has never come to pass. So our prayer today, Your Worship, is that it it looks like there is no such application in the High Court. And as such, we better have this matter fixed for hearing. We stop with it.
Just for the record, whatever he has said here is neither here nor there. The application is there. The application number was presented to this court, and even as a copy was supplied to court. So that is absolute hogwash. To say the list is absolute hogwash, that we do not file the application, and it's misleading. But that's it for the proceedings of today. We seeking to proceed. Your Worship, would you like to go on record? And we have a prayer to make. We have received instructions from the respondents, the applicants, Your Worship, to ask you to recuse from this matter. Your Worship, if it pleases you, these are the following grounds. One, Your Worship, we have gotten instructions to raise a complaint against you before the Judicial Service Commission. On grounds of maladministration of justice, incompetence, and abuse of the judicial order. Your Worship, a copy of the complaint which is already filed before the Judicial Service Commission is here for record purposes. Your Worship, you may substantiate the accused or the respondents in this matter have gotten reasonable fear and apprehension that you will not have the requisite competence to adjudicate a matter of this nature and to dispense justice, considering the antecedents and the proceedings that have happened before. First of all, the propriety of these proceedings, Your Worship, being manifestly unconstitutional. The last time the matter appeared here, the state indicated that they had finalized all the investigations they wanted to conduct and proceeded with the control proceedings, Your Worship. Under Section 168 of the Magistrate's Court Act, Your Worship, this honorable court ceases to have jurisdiction over a matter that is triable by the High Court upon conclusion of the pre-trial processes. Once the Magistrate has summed up its case, prepared the committal papers, and the file is forwarded to the High Court for purposes of trial. This Honorable Court is deemed to have exhausted its jurisdiction and has no residual powers whatsoever to handle any interlocutor application like this court is purporting to do. It's the first of its kind. If I may bring myself into the picture of the proceedings. In my 28-year practice, I have never witnessed such kind of proceedings. And I'm sure many lawyers will attest to this fact, including judicial officers, that after committal proceedings are done, that there can be any other application to be entertained by a chief magistrate whose jurisdiction is restricted to pre-trial processes. This is that the respondents here are convinced that Your Worship you have demonstrated gross incompetence in managing a matter of this magnitude with a grave offense that has reaching implications as far as their lives are concerned, which carries a death sentence. In other words, a death sentence means what? To comply with the dictates of the Constitution under Article 23 and Section 76 of the Constitution, rather of the Magistrate's Court Act. Which provisions were cited before you, Your Worship, and they are couched in mandatory terms. That once an accused person has blocked 180 days before committal, they are entitled to mandatory terms. And this Honorable Court cannot conduct any other business apart from addressing itself to the question of mandatory. And the practice guideline is what now we want to bring in, Your Worship, particularly guideline number 10.2, paragraph 2, which requires you, if you decline to grant mandatory pay, to forward the matter file to High Court. For this. Your Worship, you did not pronounce yourself on the question of whether the accused persons have spent more than 180 days on remand or not. You have never ruled on that matter. You have never made any ruling. In which case, you will proceed to determine whether they are entitled to mandatory pay or not. If you find that actually you lack the requisite jurisdiction because of the paternity practice guideline. Yes, you fall back on that guideline 10 and forwarded the file to High Court. That was never done. Your Worship, the applicants are relying on the authorities of Attorney General of the Republic of Kenya, the applicant, versus Professor Anyang' Nyong'o. This is an East African case. the East African Court of Justice at Arusha, application number 5 of it's the Bristol Betting and Game Licensing Committee. It's an expert application. This is the common law is, this is an English decision with the Supreme Court. And the principle they cited, the House of Lords, is that the policy of the common law is to protect litigants who can discharge the lesser burden of showing the real danger of bias without requiring them to show that such bias actually exists. The point here, Your Worship, is that an application for recusal is largely premised on the perception of the applicants, of the accused person, whether indeed this court will dispense justice or not. And in this particular case, Your Worship, on the basis of these authorities and the evidence before you, the accused persons are convinced beyond all shades of doubt that you will not dispense justice in a free and fair manner or impartially. Having manifestly demonstrated bias against them, and also ignoring the dictates of the Constitution to the extent that they are now languishing to zero without exactly knowing what their fate is as far as mandatory bail is concerned. They don't know. After clocking over 180 days without committal, they don't know. So we do pray that Your Worship will be pleased to recuse yourself and terminate these proceedings.
Your Worship, in further submission to our application for recusal and proceeding under guideline 7 of the Constitutional Recusal of Judicial Officers Practice Directions of 2019, the Constitutional Recusal of Judicial Officers Practice Directions of 2019, wherein Section 7 states, Guideline 7 states that a party, the proceedings may apply to a court for a judicial officer to recuse him or herself under the following circumstances, and we are interested more in sub-guideline E, that where a judicial officer makes inappropriate comments or exhibits unacceptable conduct in the course of the hearing, and in F, where a judicial officer exhibits actual, implied, or apparent bias, then they are bound to recuse themselves. Your Worship, appropriate comments that our clients think that should be the basis of your recusal are when you stated that A1 and A2 waived their right to legal representation by telling their lawyers to do what is more urgent at that time, and it was your view in open court, and the record shows that you stated that they waived their right to legal representation. Your Worship, we bring it to your attention that under Article 23, under Article 28, 3E, a right to legal representation in a capital offense can neither be derogated or waived by an accused person. And it is the reason why that specific article provides that in circumstances where private legal representation is not available, the state must avail or provide a lawyer to an accused person where the offense can lead to death. And I beg to read the specific clause in verbatim. That in the case of any offense which carries a sentence of death or imprisonment for life, the accused person shall be entitled to legal representation at the expense of the state.